Hello and welcome to the February 2024 edition of Outline. My name is Trevor Ivory. I'm the head of the UK planning team here at DLA Piper. I'm joined today by one of my colleagues in the planning team, Henry Jeffries, who's a senior associate. Morning, Henry.
Sure.
And today we're having a look at some cases and really trying to sort of pick out between us. We've picked a few of the cases that we think are probably the most interesting, the most relevant from the last 12 months or so that we thought was worth flagging up. And the first one we'll be talking about is a case on the approach to application of national policies on flood risk. A short case there, and then two cases which take us back to Hillside, which a topic we have discussed many times on Outline, but we're starting to see some interesting cases coming through on how Hillside and the Pilkington principle should be applied, and in one case how it shouldn't be gotten around in terms of trying to enable development to come forward, notwithstanding the challenges posed by the Supreme Court's decision last year. So we'll come on to those in a moment. But as ever, please do feel free to ask questions if you're watching the live broadcast. We've got the Q&A function available to you, so use those, and we'll try to answer as many of them as we can as we go. But Henry, do you want to kick us off? One of the cases you chose was the flood risk case, substation action case, isn't it? Talk us through.
Yeah, thanks, Trevor. So this is a case that was heard in the Court of Appeal in December, with judgment handed down mid-January. It related to two DCOs, but it looked at policy both under the National Policy Statement for Energy and also under the NPPF and then the accompanying PPG. So I think there's application sort of across both regimes in terms of 1990 Act development and 2008 Act development. So sort of by way of brief background, it was the appeal of a refusal of a claim for JR. There were two main grounds in the case, the first of which related to surface water flooding, and the second of which was dealing with cumulative effects. For the purpose of today, we'll focus on that surface water flooding point. And it was looking at the interpretation and then the application of policy, as I said, under the NPS, the NPPF, and then also looking at the PPG to some extent. And I think it's worth bearing in mind when looking at this case that there are obviously different sources of flooding. So the case looks at surface water flooding. There are also, for example, coastal flooding and river or fluvial flooding. And the tests for each and the policy approach for each is slightly different, which is what this case is getting at. So at a high level, the NPS requires decision makers to meet the policy aim of ensuring that flood risk from all sources is taken into account at all stages of the planning process, and the aim really is to avoid inappropriate development in areas of highest risk and to move development away from those areas of highest risk. And one of the ways in which the NPS requires applicants and then decision makers to do that is through the application of something called the sequential test. And the sequential test applies at the site selection stage, and then also when you're looking at the location of development on a site, there's also an approach there in terms of a sequential approach to ensure that development within the site is located away from the areas of highest risk. And the sequential test is a concept that comes from the NPPF, and essentially that's looking at the idea that in the context of fluvial flooding, at least, you first of all look at trying to site development in low risk areas, so flood zone 1 for the purposes of fluvial and coastal flooding. And then if you can't locate in flood zone 1, you look at flood zone 2, and the test there is whether there are any other reasonably available sites. And then again, you move to flood zone 3, and are there any other reasonably available sites? And what the court was looking at here was whether that very prescriptive approach in terms of looking at other reasonably available sites applied to surface water flooding. And interestingly, the court held that no, it didn't. And largely that was due to that reference to the flood risk zones, which relate to coastal and fluvial flooding. And in handing down the judgment, the court sort of split the judgment into on this ground into two parts. So the first point was interpretation of policy, which is that first point. And it said that it was apparent from the relevant policies and guidance that the risk of flooding from surface water had to be taken into account at all stages. However, it was a matter of planning judgment for decision maker to decide how that was taken into account. So there wasn't a requirement to apply the sequential test in relation to surface water flooding. And in terms of the exercise of planning judgment, the court didn't find that the Secretary of State had acted unreasonably or outwit their powers in sort of applying their judgment to that broader test. So that's broadly speaking what the judgment says. I think there are still some questions left unanswered as we move forward, but I think it's a useful position in terms of the NPPF interpretation, at least.
Yeah, and it's interesting because it's the application of the NPPF in a DCO, isn't it? So kind of it's one of those cases where actually it applies. On the face of it, you sort of look at it and think, oh, it's a DCO case. Anyone doing the 1990 Act doesn't need to think about it, but it clearly is relevant because it's going back to that sort of NPPF approach to flooding. And it's sort of slightly, I think there's a real logic to what the court was saying, and it's sort of slightly surprising to me that the challenge had been brought. It was brought by a third-party group, wasn't it? An objector group, I think.
Yeah, I think.
Sorry, I was just going to say, so it's useful to have that clarity, so we don't have to keep having the argument that actually in the context of surface water flooding, you don't have to apply the sequential test in the same way, because it's quite a draconian test, isn't it? If you get to that, particularly flood zone 3, if you get to that reasonable alternative sites, that's quite a high bar if you're trying to bring forward development. Yeah,
it is, and there are lines of case law on that test as well, which is a separate point. But I think the interesting point on this is, at least in terms of appeal decisions, the approach that was applied previously was looking to sort of draw the sequential test across to other sources of flooding as well as fluvial and coastal. So, as you say, I think it provides a useful steer. It's worth noting that the version of the MPF and the PPG, and I suppose the NPS that were being looked at in the case, were those that applied at the time of the DCO applications. So the wording in the MPF is substantially the same. The PPG has changed slightly, so there is potentially more room for manoeuvre there in terms of, would a different approach apply in terms of the PPG at least? And I suppose the point there is that that's guidance as opposed to necessarily policy.
Yeah, the sort of the starting point is the NPPF wording, isn't it?
Exactly.
That's the policy basis, but certainly those changes to the PPG since the relevant policies that were considered by the court in this case, they have muddied the water, haven't they?
Yeah, they have. So I think the version of the PPG that applied when these applications for DCAs were made was very clear in terms of linking the sequential test to flood zone 1, 2, and 3, which, as I said, that's sort of the link that gives you the coastal or fluvial point. I think now there's wording in there that refers to any sources of flooding in the context of the sequential test, which in some ways mirrors I think it's paragraph 168 of the NPPF that the court was considering. It slightly mirrors the wording there, so you could draw the court's reasoning across, but I think there is room for discussion at least.
Yeah, but I think on balance, notwithstanding those subsequent changes to the PPG, I think it still seems to me that the case is probably applicable because the wording is the wording of the NPPF is effectively what they considered, isn't it? So it feels as if there is still that distinction to be drawn, which is helpful.
Yeah, agreed.
Great. Well, that was our quick flooding case. Onto the main event, I suppose, which is a return to Hillside in a couple of cases that have come out in the last few months around Hillside. But just as a sort of quick reminder of what the Hillside case itself was dealing with. The Hillside case, there is a whole outline session on Hillside, so anybody that wants to catch up in detail can catch up with that via our YouTube channel. But effectively, the Hillside case was looking at something called the Pilkington principle, and it was considered by the Supreme Court last year. And the fundamental point that came out of that case was around the implications if you've already started development under a planning permission and you then commence development under a new planning permission where there is an overlap between the two sites. The Pilkington principle looks at the impact of that implementation rather of the second permission on the validity of and status of the first planning permission. Effectively, what the Supreme Court said in a nutshell was that if, having implemented that second permission, the consequence is that it is now physically impossible, that's the test, physically impossible to complete the development that was consented under the first permission, then no further development under that first permission can be brought forward. So effectively, you lose the benefit of that first permission to the extent you haven't already built it out before you implement that second permission. So that's the key point that came out of Hillside and is relevant, I think, to the cases we're about to look at. The other point that's probably worth just reminding people of is one of the things that the Supreme Court looked at in coming to that conclusion on Hillside was the question of whether or not a planning permission was severable. So did a planning permission, as a matter of fact, grant planning permission for a single development, or was it in effect granting a series of separate planning permissions for a series of separate developments? And in that context, it was a residential permission they were looking at, and there was an argument that it wasn't planning permission for a housing estate, it was planning permission for a series of discrete planning permissions for a series of discrete houses. And the idea of that, had that argument succeeded, was that therefore, if you could no longer build out a few of those houses, it didn't mean that you couldn't build out the rest of the estate under that original permission, because you could sever the different plots from each other. The Supreme Court didn't say that that was wrong, but what the Supreme Court said was that it was highly unlikely, in the absence of a very clear and explicit intention on the part of the planning authority, it was highly unlikely that a planning permission was ever intended to be severable in that way. It was ever intended to be a series of discrete planning permissions. So they didn't rule it out, but they found on the facts of Hillside that that permission wasn't a severable planning permission, and they questioned how likely it was that in reality planning authorities would ever, in a modern context, grant severable planning permissions. So that's Hillside, but I think the case, the really interesting one for me is a High Court decision that again from last month, January. It's High Court decision. It's Mr. Justice Holgate, so senior judge in the planning court, and very well respected. And the case involves, so the case is Dennis, and the case involves large regeneration site, the Aylesbury estate in London Borough of Southwark. And a planning permission had been granted, an outline planning permission had been granted for a significant regeneration over quite a large area. I think it's about 4,500 residential units. It was the critical points, I think, where it was an outline planning permission and it tended to come forward in phases. The planning permission itself had a fairly usual description of development. It set out all the different uses that were going to be part of this big regen scheme. There were phasing plans, there were parameter plans, there was all the normal stuff you'd expect with a big development. And there were some conditions, one requiring development to be carried out in accordance with the plans. Another condition that was significant was requiring development to be carried out in accordance with certain documents, notably the planning statement and the design and access statement. Within the design and access statement, there was a phasing program that showed the order in which the phases came forward or needed to come forward. Part of the reason for that was it was an existing residential area, so there were residential relocations that needed to happen as part of the development. So there was a sort of logic to needing the phases to come forward in a particular way. Development carried out, the first few phases had been built out. Then the developer comes along and puts in an application for a new detailed planning permission for one of the phases, and is intending to implement that new detailed permission on that phase instead of relying on the outline permission. They were alive to Hillside and to the risk, if they did that, of physical impossibility and therefore a potential Hillside issue. The approach that they took in agreement with Southwark, the planning authority. So the developer and Southwark both agreed that the planning permission, because it was phased, the planning permission was in fact a severable planning permission. So that was the position that both the developer and the planning authority arrived at. They then decided, in order to make it clear that it was a severable planning permission, they would use an application under section 96A for a non-material amendment to insert the word severable into the description of development. And you can use 96A to change the description of development, but of course 96A you can only use if the change you're making is immaterial. That approach was challenged by Mason Dennis, and the matter came before the High Court at the back end of last year. When it came to the High Court, it was common ground between all the parties that if the planning permission was not severable to start with, then the 96A was ultra vires and was unlawful, because it was agreed that making a non-severable planning permission severable would inevitably be material. So the first question the court had to grapple with was the planning permission severable in the sense used by Hillside and the Supreme Court last year. So that was kind of that's the background to the case, and I think there's some interesting points that come out of it. And the first one is really around that severability, isn't it, Henry?
Yeah, I think that's right. And I think it was made fairly clear in Hillside, but the court in Dennis sort of reiterated that point and said that the way in which you identify severability is that point around freestanding permissions. Is this a series of permissions, or is it a single permission? It's sort of as clear as that. And I think the point which was reiterated in Dennis is, unless there's a clear intention, that's very unlikely to be the case. I think applying that to the facts of this case, the appellant was arguing that the presence of the outline permission and the phases sort of pointed towards severability. I think the court was very clear that wasn't enough in this case. I think going against that point was the fact that as you said, the design and access statement was linking between the phases. So it wasn't even a case of it being a phase permission you could implement as you chose. It was a case of you had to follow the order of the phasing. So if you were to take out, if you like, one of those standalone phases, you'd be left with potentially an issue there around those subsequent phases due to the design and access statement.
I mean, it feels like quite a bold argument, or brave argument, as a civil servant would say, for them to advance, because there was lots of stuff that showed that this was quite comprehensive. I mean, I think the planning statement, which again was a document that was conditioned, the planning statement referred to it as being a comprehensive regeneration and a comprehensive redevelopment. But all of that seems to me, it was quite. I think the judge was quite right to say this is not a series of discrete planning permissions. This is a single comprehensive master plan for a regeneration scheme. And I think when you look at the judge's comments, the general principle that I think comes out of it is the mere fact that the permission's in outline, or that it's phased, just is nowhere near enough to meet that test that the Supreme Court said of, very explicit, I think his wording they use, very explicit intention to grant a severable series of planning permissions. So I think anyone looking to overcome Hillside who thinks that the way to do it is by arguing for a severable permission needs to think very carefully, because it's going to have to be very, very clear on the face of it that it is severable. The mere fact it's outlined, the mere fact it's phased isn't enough. And particularly keep an eye on those documents which get incorporated into planning permission by the condition. And more and more, it's perfectly normal now, I think, to see a condition that says you'll build strictly in accordance with the planning statement, design and access statement, and all sorts of other things, flood risk assessment and everything else. So you've got to have an eye on what those documents say as well, because they've been incorporated into the planning permission by virtue of the condition.
Yeah, and I think it's interesting here, obviously, the points are raised here in the context of a 96A application. The point could equally arise when it came to enforcement. if a hillside issue arose, if you were arguing, or developer was arguing, that the underlying permission was severable. So it's not a case of it will only arise if you're looking at 96A. I think it would arise in the enforcement scenario as well, and it's one which would be a hard argument to run, I think.
Yeah, yeah. I think the sort of, just as an aside, one of Holgate's comments in the judgment was almost a sort of "be careful what you wish for" paragraph in there, which is where he was sort of saying, actually, you need to think carefully before you try and argue that this is a severable planning permission, because in his mind, if it were a severable planning permission, then what you have is a series of individual planning permissions. As a result, each one would need to be lawfully implemented within the statutory time limit, or within the time limit on the condition, the sort of usual 3-year, 5-year, in the case of an outline. And so the point he was making was, even if it was severable, actually, because they hadn't implemented the later phases, they were out of time doing so, because the physical start on phase 1 would not be enough to implement phase 2 if it were indeed severable. So I kind of think the developers here at that point were on a hiding to nothing, because even if they'd have managed to persuade him it was severable, what he was saying was, well, even if that were the case, I'd then be telling you that actually you could no longer develop those later phases because the planning permission had lapsed, unimplemented in respect to those phases. So I think severability feels like a highly risky way of trying to overcome the Pilkington and Hillside principle for me.
Yeah, especially if you're trying to apply it retrospectively, essentially. If it hasn't been thought about at the time of the original application, if you're trying to then retrospectively apply the concept of severability, there are going to be issues, aren't there?
Yeah, yeah. But I suppose where does that leave us is the interesting and the practical point. And it seems to me there are still sensible solutions to Hillside. I think, in this case, they just did it wrong. There is a better way of doing it. And to my mind, 96A is a big part of that. And certainly the approach that we've been taking, advising our clients on Hillside, is to use the slot-in approach, as I think it's sort of generally becoming known. And so in that case, you get your planning permission for your second planning permission, but before you implement it, you use 96A to amend the original planning permission in order to effectively grey out or white out the area that the new permission is going to slot into, so that the original permission is, the result of it is that it's not permitting any development within the area that the new permission is going into. And as a result, there is no physical impossibility, because there's nothing you could bring forward under that modified permission. And I think that for me still seems to be a very sensible approach. And I don't think there's anything in the Dennis judgment that changes that. The Dennis judgment reminds us about materiality and reminds us that there are limits to what is material. But I think that the judge's finding on materiality, Henry, was around the point that taking a non-severable planning permission and making it severable is inevitably material. But that seems to me that doesn't change that sort of the more nuanced approach of a slot in and greying out. I don't think that is affected by the judgment. I think there is still an argument that works, and that those changes can be, not necessarily will be, but can be non-material and therefore capable of being done by 96A.
Yeah, I think the key point there is can be, isn't it, as you say, because it's a 96 application in the usual way. So if it is material, it won't be within the scope of 96A.
Yeah.
And that's the point to bear in mind. I think Dennis is a useful reminder of that. But as you say, I don't think it's the way that we've seen clients looking to preempt or avoid hillside issues, looking at this severability argument to date.
Yeah. So in terms of the slot-in, just sort of thinking about the practicalities of that, I think one of the things which I've had the debate with fellow planning lawyers about, so there's a slightly different approach. So the approach that I've advised clients is that you get your new planning permission and then you apply for your 96A. And I think there are a couple of reasons why you do it that way round. The first is a practical one, which is if you get your 96A and grey out, effectively lose the ability to develop part of your site under the original permission before you get your new permission, then there's a risk If you get your new permit, if you can't get your new permission, you've then lost your ability to develop anything in that area because you no longer have a planning permission that covers it. So there's a practical. But interestingly, I've seen, as I say, sort of quite well-known planning lawyers advising that it should be done the other way around. You should do the 96A first and then get the new permission. And I have to say, as well as the practical reason that I've just outlined why that doesn't sit comfortably with me, I think the other thing is around this question of materiality. If you are making that 96A change up front, it may well be material, and ultimately materiality is a matter of planning judgment. It's for the planning authority to decide, and they may decide that change is material just on its own. Whereas it seems to me, if you've already secured the new planning permission, then you will have already gone through public consultation, you'll have had the statutory consultees, will have had their say. If EIA is necessary, then EIA will have happened. It will all have been assessed in all the various different ways that a planning application is considered. And at the end of it, the planning authority would have reached the conclusion that that new development is appropriate, and is appropriate in the context of an assumption that the rest of the development under the original planning permission is going to come forward. And therefore, it seems to me that whilst the 96A may have been material and therefore not capable of being a 96A before that decision's been reached, in many cases, it may become less material after, because that principle of development has been established in a robust way. So it seems to me that that's a good reason for making sure that you get your planning permission first, and then look, before you implement that planning permission, of course, but look to then get your 96A after, rather than, as I say, the way I've seen some of our colleagues in other firms to advise it, which is to do it the other way around.
Yeah, and I think it's worth saying as well, Trevor, isn't it, that in this case, that's the order in which the permissions went in. So they got their slot in permission first, if you like, and then they went for the 96A. But the issue they had here was, as we touched on earlier, rather than looking at that sort of more nuanced approach in terms of greying out an area on a plan and then looking at the knock-on impacts of conditions, it was just a simple insertion of severable was the proposal for the 96A. And I think that's where they came unstuck, if you like, rather than that ordering point.
Yeah, absolutely right. And I think, reading the judgment, I don't think they'd actually implemented the new permission. And so all is not lost for them, because they could still do the slot-in approach. Instead of trying to claim that the permission is severable, they could simply just grey out the phase and still be able to implement both those consents together. I think when you're doing that, and one of the things they'd have to do here is you have to be quite forensic, and a number of sites that I've done it on, you have to go through and think about what are the things that need changing, because it's not necessarily just amending the plan. And here it clearly wouldn't be. There would need to be a substitution of a new DAS or an amendment to the DAS, changes to the planning statement as well. So I think if you're going down that route, you do need to get some proper advice on what exactly needs to be covered by the 96A to make sure you're picking up everything. Because if you leave one thing there that still remains and makes it potentially physically impossible, then you're still creating that hillside Pilkington risk. But all is not lost for the developers in Southwark there. It seems to me they've still got the opportunity to do it that way around, provided that the planning authority is persuaded that the changes you're trying to make are not material. It seems to me that may well be the case.
Yeah, I agree. And I suppose one of the things with Hillside is it's such a well-known or well-publicised case. It's one where objectors are likely to pick up on it, aren't they, in terms of people will have heard of Hillside. It's not one of those more obscure points which people pick up on. It's one which I think people have in the front of their mind if they're looking to object to things.
Yeah.
It's important to be clear on how you're going to deal with it.
It is. We've just had a question come through just asking us to clarify the timeline. So just to be really clear, I think the approach, and you'd always have to look at this in a particular context. So you make sure you get advice on each one. But I think that sort of the most appropriate approach will be, you've got your original permission, you then get your new permission, and before you implement that new permission, you then use 96A to amend the original permission to remove that physical impossibility. I think that is, to my mind, usually going to be the right order to do it. But I think in each case, you make sure you get advice and make sure that you've got a strategy that works in the particular context. But that feels to me like the approach that's normally going to de-risk it for a developer, but also assist a planning authority with coming to the conclusion that the 96A is not material because the principle of those changes has already been accepted through a full planning application. So that's Dennis. And then with the last case you want to talk about, Henry, was another one which actually we have talked about before, the Fisk case, which we talked about on a previous outline in the High Court. But that decision has now recently been the subject of appeal in the Court of Appeal. And again, it's raising hillside type issues, isn't it? So you just want to remind us of what Fisk was looking at.
Yeah, sure. So Fisk was solar development, the solar park. And there was, going back to that sort of ordering permissions you just referred to, in 2017, there was an original planning permission for solar park development, and that included a 33 kV substation. In 2021, there was another full planning permission granted for solar park development on the same site, which included provision for a 132 kV substation and other development within that site. So on the application for the 2021 permission, it was common ground that the two permissions would be incompatible. So it wouldn't be possible to build out both permissions due to the location of the substation and I think access as well. The planning officer was aware of the previous permission, the 2017 permission, but didn't expressly address sort of hillside issues of incompatibility, etc. in the report. And the 2021 permission was granted. So the appellant was judicially reviewing that decision to grant the second permission and saying that the incompatibility in the presence of the 2017 permission is a material consideration that should have been taken into account at the grant of permission. So it's an interesting case in that we've just been speaking about sort of looking at it from the developer side of things. This is very much a case of looking at what is the thought process and the considerations that a local planning authority has to take into account when they're looking at subsequent planning permissions. And the Court of Appeal's judgment upheld the High Court judgment. There's no change, but I think it's a useful reminder in that they said that the presence of a previous permission and an incompatibility between the two isn't a mandatory material consideration, in that there's no requirement to take it into account. I think the interesting point though, Trevor, is that while it isn't a mandatory consideration, they didn't close out the possibility of it being a consideration. So it's not quite as clear cut as it might be on first reading.
I think that's right, and that comes out actually a little bit more in the Court of Appeal's judgment, perhaps, than it did in the High Court. So I think that's a bit sort of worth just revisiting, because the sort of question was whether the fact that it hadn't been considered in the officer's report and by the planning committee before the grant, whether that was an automatic failing, and so this sort of concept of a mandatory material consideration, i.e. something that a planning authority has to consider, even if it hasn't been raised by anybody as a point to take into account. And so, probably not surprisingly, it seems to me, the judgment starts by saying, no, this is not something you have to take into account, even if it hasn't been raised with you. But you're right to say what it then goes on to say is that doesn't mean it's not always it's not ever a material consideration. The fact that you're granting planning permission for something that is physically incompatible with a previous extant consent might be a material consideration. So a planning authority can take it into account, but it doesn't have to.
Yeah, and I think the point that the court made as well, wasn't it, was that in essence, that incompatibility is a matter for the developer to deal with how they choose to. Because as we've just been discussing, there are mechanisms by which you can avoid a hillside type issue arising, be that 96A or Section 73 or whatever else you might choose to do. So really it's for the developer to decide how to deal with that incompatibility, or to accept incompatibility and just implement the second permission and lose the first one. So it would be slightly strange if you had a local planning authority sort of making that decision, if you like, for the developer.
Absolutely. As a landowner, you're perfectly entitled to get as many planning permissions as you like for your land. You can have a retail one, a residential one, or an industrial one, as many as you can get, and then you would have a choice as to which one to implement. That's quite a fundamental basic principle, isn't it? I think kind of actually putting the two cases together, if we go back to Dennis, that's an interesting thought though, around the question of the materiality of a section 96A. There's an extension of that in that actually when Southwark were deciding to grant that second planning permission, they could have come to the view, I suppose, in the context of what they were seeking to achieve, what their local policies were seeking to achieve, of a comprehensive regeneration of the area. They could have said in that case, actually, that is a material consideration because we want to see this area developed comprehensively. And therefore, that might, I can see in that sort of scenario that actually it may be a material consideration that a planning authority would want to place weight on if they had good planning reasons why they wanted particularly a comprehensive development. That could be a reason to say no to an incompatible planning application that's made subsequently. But it feels like that's very much the exception and is not going to be the sort of standard approach. And that very much is, I think, what the Court of Appeal were, as indeed was Mrs. Justice Lang in the High Court before them, and saying, no, ultimately grant as many planning permissions as you like, let the developer worry about which ones they implement and how they fit together. And ultimately, it's a matter of enforcement if a developer is trying to implement two, and there is that physical incompatibility that or impossibility that the Supreme Court talked about in Hillside. So I think it's sort of it could be a material consideration, but it's unlikely to be, and it's certainly not something that a planning authority has to take into account every time, unless it's raised. If it's raised, they will have to consider it and decide what weight to place on it. But if it's not raised with them, there's no legal obligation on them to think about it, and that seems to me to be a very sensible conclusion that the Court of Appeal have come to, as indeed the High Court had come to when we discussed the case previously.
Yeah, agreed. I suppose I was just thinking one of the things which I don't think we had in mind when we discussed Hillside previously was section 73B of the Town and Country Planning Act.
Largely, it didn't exist.
Yes, correct. That's what I was just going to come on to. It wasn't an omission on our part, which I think we have discussed previously in terms of is there a difference between section 73B and 96A? And for context, section 73B, when it comes into force, or if it comes into force, provides for applications permissions that are not substantially different from an existing permission. So it's a different test. And I think that the point there as well is that rather, as for section 73, providing for a separate planning permission, it is an amendment to an existing permission. So potentially you could see, if that would come into force, a separate line of case law, or attempts at least, to shoehorn section 96A scenarios into that section 73B bracket if developers thought they could argue that not substantially different was different from non-material amendment. I think that's one to watch potentially. I'm not sure if there's too much to think about now, but
I think it's a really good point to raise, because of course it is now in with the Levelling Up Act now being an act. It's now on the statute book, although I think the critical point is it's not yet in force, as you said.
Yeah, correct.
But when it does, it's another means that sort of tries to circumvent some of the limitations of section 73 in terms of that inability to change the description of development that limits section 73, but also, as you say, it's a higher bar than the materiality point, so it does create scope for an alternative route through that sits somewhere between section 73 and section 96A. So I think it will, if it comes in, which there are question marks over quite how much, particularly if there's a general election and a change of administration, question marks over which bits of the act will ever come into force. But that certainly is one that I hope we would see, because it might be limited in how frequently it's used, but it will be a useful power to have available for planning authorities and landowners to use.
Yeah, one to watch, I think.
one to watch. Great. Well, those were the cases that we wanted to flag up. So Henry, thank you very much for that. Thank you to our audience as ever. Our next edition of Outline is on the 21st of March, and we will be looking at how you should approach the interpretation and application of planning policy. So we're looking at some of the pitfalls and the mistakes that people make in trying to apply the myriad forms of policy, whether it's local, national, or something in between. So that's our topic for the 21st of March. Look forward to seeing people then. And in the meantime, thank you again, Henry, and thanks to our audience. Goodbye.
Thanks all.